When we talk about Indian affairs, we always start with a couple of main concepts. The main one and most important one is inherent tribal sovereignty, the rights to govern that tribes held from time immemorial. And they've always had these rights. They've always had the right to govern their own native nations in their own way. That's something that's always been in place. Now, there was the incursion of the Europeans starting in 1492 or so, and we had all kinds of other European nations coming over, trying to figure out how to deal with the Indian tribes. Ultimately, what got entered into were agreements with tribes, mainly because tribes had a significant military might in comparison with the Europeans. The Pope had something to say about dealings with Indian tribes. A lot of Spanish theologians weighed in as to how Indian tribes should be dealt with. The decades and centuries moved on towards the start of the United States. The English were the last ones to win the great battle for the North American continent, because there had been Dutch and even Swedes, and certainly the French. As the colonists were thinking about creating revolution, they were all kind of led by British trained attorneys, whether it was Jefferson or Madison or John Jay or Alexander Hamilton. So they all adopted the ways of England when they were writing up the Constitution. England had been entering into treaties with Indian tribes, and that had been the custom, and so they followed that. So when they wrote the Constitution in the summer of 1787, they had to make some decisions about how Indian tribes were going to be dealt with, because it was an important aspect of the new government. And the Articles of Confederation, which preceded the U.S. Constitution, had some loose provisions with regard to dealings with Indian tribes. And they were supposed to allow for the central government, the federal government, to deal with the tribes. When the Constitution was written in the summer of 1787, the decision was made, let's put the centralized authority over Indians into the hands of the central government, the federal government. There were a couple of powers that were put into the Constitution that were important. One was the treaty-making authority, so treaties get made by the executive branch, get negotiated by the executive branch, and get ratified by a two-thirds majority of the Senate. And then there was the Commerce Clause, and the Commerce Clause is where tribes point to today as a place in the Constitution where they're placed on a par with other governments. Their native nations are in the Commerce Clause, because the way the Commerce Clause reads in the Constitution, it's Article 1, Section 8, and it says that the Congress is going to have the authority to regulate commerce with foreign nations, between the states, and with Indian tribes. Now, if you think about that, that's three different kinds of sovereigns. And so native nations are put on the same level as states and foreign nations. So in the Commerce Clause is where we point to today. Treaties got entered into, close to 400 of them. A lot more got negotiated that weren't ratified by the Senate. And so treaties are still good law. Treaty making ended in 1871, but the Congress stated at that point in time that the treaties that were in place are still good law. Treaties are still important to this day, as is this power of the Constitution. So the Constitution creates, of course, three branches of government. At various times in history, the different branches have come to preeminence with regard to Indian tribes. The judicial branch was very important in the early days of the Republic with regard to tribal-state relations and also relations with Indian tribes. There were a series of cases called the Marshall Trilogy, essentially stating a number of things. One, that it was going to be the federal government that dealt with Indians on land matters. Second, that tribes are not exactly foreign nations, but they're domestic dependent nations. They retain sovereignty, and the relationship between the United States and the tribes is similar to that of a guardian and his ward. And so the United States was like a guardian, the tribes were like a ward. That evolved into what is called the trust relationship, where the United States is the trustee of American Indian assets. And if you ask the BIA, it's mainly land and water. But to the tribes, it's all kinds of other things, and that's been implemented in statutes and various things from health care to housing. So there is an ongoing trust responsibility that flows from the United States to the tribes. The legislative branch of the Congress becomes more important as the years roll by. It was always important, of course, but through committees they write a series of legislation. For a while, the Senate was making the treaties until 1871, and then Congress starts passing acts over the tribes. The General Allotment Act in 1887, the way that was implemented in Minnesota was called the Nelson Act in 1889, and so they kind of head towards allotments and attempted assimilation from 1887 until 1934. Now, in 1934, the Indian Reorganization Act passes. And there had been a report in 1928 indicating that this allotment policy for tribes was not working at all. In fact, Indian reservations were becoming these vast pockets of poverty in the United States, and some of the poorest counties and poorest regions of the United States were in fact the native nations. And so the IRA, as they call it in Indian country, provided tribes a chance to work with the federal government to create constitutions, have secretarial elections, and Professor Matthew Fletcher kind of looks at this, the way this act is worded, as this is usually a term that's used in bankruptcy law, reorganization, and so he kind of discusses it as, you know, the Indian tribes were the functional equivalent of bankrupt entities from this particular perspective. So economically, the tribes were hitting rock bottom. So not all tribes adopted parts of this, but there was, under the executive branch, the Interior Department got created in 1849. And the Bureau of Indian Affairs had been around since 1824, but it started under the Department of War. They basically implement the laws of the United States, and they were responsible of implementing the Indian Reorganization Act. Now, Section 16 of the Act allows for tribal constitutions. Now, a lot of these constitutions were sort of what they call cookie cutter constitutions. A lot of them were directly drafted by people in the Interior Department, and a lot of times tribes had not that much say in how they got drafted. They were kind of handed a constitution. And so under the IRA, the Minnesota Chippewa tribe gets formed officially in 1936 under an IRA constitution. The basic frameworks of the Constitution are in the Indian Reorganization Act. The elections that are held under the Minnesota Chippewa tribe are done pursuant to the Act, and then the Secretary of Interior, any regulations they have. And so the Minnesota Chippewa tribe gets formed. It gets amended in '64, gets changed up a little bit, but for the most part, it maintains this structure of a centralized committee. And so the Minnesota Chippewa Tribal Executive Committee, or TEC as it's called, is made up of the chairperson and the secretary-treasurer of each band. So under the Minnesota Chippewa tribe Constitution, there are 6 bands. In each of the 6 bands, after the '64 changes that were made, there is a chairperson, a secretary-treasurer, and then 3 reservation business committee members. The 2 top people that are elected at large, the chairperson of the tribe and the secretary-treasurer, they sit on the Tribal Executive Committee of the Minnesota Chippewa tribe, or the TEC. So there's 12 of them, and they make policy. But basically, the Tribal Executive Committee is together for pretty much 3 reasons. The first reason is all 6 bands do elections together. They do an election ordinance. They update the election ordinance from time to time. Second, they set the membership for the Minnesota Chippewa tribe. So right now, there's a requirement that you be 1/4 blood quantum. Now that's changed throughout history, but that's the rule right now. The third reason is when they started the Minnesota Chippewa tribe in '36, a lot of the bands didn't have much land. Under the IRA, tribes were allowed to put land into trust into perpetuity. And so that's why lands are placed in a trust. So there's elections, and then there's membership, and then there are lands held in trust for the Minnesota Chippewa tribe on all 6 reservations. And that's the way it was until '64. With the '64 amendments, bands were allowed to take land into trust for the bands. So if you look at a plat map of any of the 6 reservations, you'll see some lands held in fee, like at Bois Fort, where I'm from. There's a lot of lands that are held by timber companies and Diamond Match and other entities. There's lands that are held in trust for the Minnesota Chippewa tribe, lands held in trust for the Bois Fort band, and on some reservations there's allotments under the Nelson Act, which was the way the General Allotment Act was implemented in Minnesota. And so, interestingly enough, if you look at the revisions to the Minnesota Chippewa Tribe Constitution, under Article 6 of the bylaws, the reservation business committees are the RBCs, which are the entities that were kind of put in place to deal with the bands themselves. So the bands have those in place. Today, a lot of the bands don't call themselves reservation business committees. They think of themselves as governments. And so what Article 6 of the bylaws of the Minnesota Chippewa Tribe Constitution says is that RBCs are allowed to make laws and be governed by them. And so they can also assign roles to the different officers. And so one example is Mille Lacs, where they have created a separation of powers form of government. They took the chairman position and made that person the chief executive and put commissioners under the chief executive. They took the secretary-treasurer position and made that person the speaker of the band assembly, a legislative branch. And then they did something that they, weren't necessarily, wasn't specified in the Minnesota Chippewa Tribe Constitution they could do. They created a judicial branch. The solicitor's office, the regional solicitor's office, wrote an opinion on this in 1983, whether or not they could do these and change these roles like this. They said as long as they stayed under the aegis of the Minnesota Chippewa Tribe Constitution, they could designate these roles. They said the court was subject to challenge. But at that point in time, the way folks were reading the Minnesota Chippewa Tribe Constitution was they thought that all powers were deriving from the Minnesota Chippewa Tribe Constitution. The Department of Interior took a whole different look at that during the '90s, and they said, when faced with the question whether the bands of the Minnesota Chippewa Tribe could have their own courts or court systems, they said, yes, they have the inherent tribal sovereignty to do that. And so the reservation business committees can be, are governed by this Constitution, but this inherent tribal sovereignty that's been in place from time immemorial still kicks in for the 6 bands, because they have this self-governing authority that is pretty much, on a par or supersedes the Constitution of the United States. That is something that they always retained, the right to be a self-governing Native nations. Now, under the acts of Congress, under the way the executive branch interacts with the bands, they are each recognized as their own independent sovereigns. So whether it's gaming compacts, and you have to be a federally recognized Indian tribe to enter into a gaming compact with an Indian tribe. So that's the state entering into the compact with the tribe, but it's governed by federal law. So the Indian Gaming Regulatory Act says you can enter a Class 3 compact for games beyond bingo and pull tabs if you're a federally recognized tribe. So all 6 bands have 2 compacts with the state of Minnesota on gaming. They also have entered into self-governance, which is an act that for the BIA passed the federal government in 1994, and then for IHS passed in the year 2000. All of them are self-governance tribes, and so they have compacts with the United States. Each band does individually under the self-governance law. So over time, there's been additional autonomy for these reservation business committees. A lot of them are calling themselves reservation tribal councils. Mille Lacs has a separation of powers form of government where they have an executive, legislative, and judicial branch. So it all comes back to this original concept of inherent tribal sovereignty, really. The ability to govern yourself, starts at the grassroots in one way. In another way, this Constitution is still in place, and for those three reasons I stated, will continue to stay in place. There's a couple of ways to change it. Section 17 of the Constitution allows for amendments, and it can always be, there's also a provision it can always be changed by the Congress. So the Minnesota Chippewa tribe is unique in this structure, because the way there's actually a federal law that requires for a list of tribes. Now, the Minnesota Chippewa tribe itself is a federally recognized tribe, but so are the 6 bands that come underneath it. So Bois Forte, Fond du Lac, Leech Lake, Mille Lacs, Grand Portage, White Earth. And they're each federally recognized tribes themselves. There's no other constitution like this in the United States. There's no other model quite like this. So I think that's why there's usually an internal struggle going on as to what all this means, because the bands understand that they have inherent tribal sovereignty, the right to govern themselves. At the same time, they're still under this Constitution. Said, as long as you stay under this, you're okay. So they're interpreting the provisions of this in their own way. Now today, all the bands have tribal courts, to my knowledge, and they all exercise judicial authority, which is not in the Minnesota Chippewa Tribe Constitution. It comes from the inherent sovereignty of the bands themselves. This is a unique entity in that the main entity is a federally recognized tribe, but the 6 constituent bands are also federally recognized tribes. So there's nothing exactly like this in the United States anyplace else.